Professor Ling Bing does not need much introduction at all. He's very well known. He's one of the top international law scholars in international law in general and on China and international law in particular. He's currently a professor of Chinese law in the Sydney Law School, and before that, he taught in Hong Kong for many years in this university, City University of Hong Kong School of Law, and also in Chinese University of Hong Kong Faculty of Law, where Professor Ling and I were colleagues for a number of years, and we also became very good, very close friends. Professor Ling Bing, I guess, earned a lot of reputation during the South China Sea arbitration when he made very bold and provocative and thoughtful remarks, which made him quite well known. And I was also I also had the honor to take part in that debate, and we also have with us Professor Gao Shengqi from Wuhan University, the Institute of International Law. Like Professor Ling Bing, Professor Gao also needs little introduction. He's very well known for his solid research on law of the sea and other public international law. I read a lot of his work about the South China Sea arbitration and other issues. So Professor Gao Shengqi will serve as our discussant. I also have my colleague, Dr. Fuzia Long, who is an expert on international law and especially human rights law. And she has been working on Sino-India border dispute for a number of years. Is going to have a monograph published very soon. So she is also a very suitable discussant for the topic today. What we are going to do is we will proceed like this. Professor Ling will give a presentation for about 30 to 45 minutes, and then each discussant will be given about 50 minutes. I am the chairperson, but I also function as the third discussant, and then we will take questions. We will ask Professor Ling Bing to respond, and then we will open the floor for question and answer. So this is how it will be going. So without further ado, we would invite Professor Ling Bing to start with his presentation. Please, Professor Ling.
Thank you very much, Jiang, for that very kind introduction. It is a great honor for me to start this very important seminar series at City University. My topic today is about China's engagement with international judicial dispute settlement. Will non-appearance be the new normal? Let me just first share the screen with you and put up the PowerPoint. All right. Now, before I started today, actually, I was thinking about not showing up for this seminar, just to make the point that non-appearance will be the new normal. But I thought better of it. It's great to be back here virtually at City University, where I worked about 20 years ago. Let me start with the breaking news. The breaking news for today is this Chinese Communist Party resolution on major achievement and historical experience, which was just released by the Communist Party Central Committee just a few days ago, earlier this week. Now, as many of you probably know, this is the Communist Party's third major resolution on history. Unlike the first two resolutions, this one does mention international law, if only just once. So this is the reference to international law here in that resolution. If you can look at the screen, I quote, China has actively participated in reform and development of the global governance system. It has worked to safeguard the international system centered on the UN, the international order underpinned by international law, and the basic norms of international relations based on the purposes and principles of the UN Charter. So China has safeguarded the international order based on international law. And I think everybody probably would agree that the international judicial institutions and judicial processes are an integral part of that international order. Now, in that regard, China, as many of you would know, has been actually actively engaged in the international judicial process in some sectors. So for instance, China has participated in numerous cases before the WTO dispute settlement body. China is also engaged with the ICSID investment arbitration process. Now, my seminar today, my presentation today, actually will not be addressing these two areas of international judicial process. They are no doubt important, but I would rather try to address the giant panda in the room, so to speak. When we talk about China's engagement with the international judicial dispute settlement, I think most people's mind will be on the South China Sea arbitration case, in which China refused to appear before the tribunal in the arbitral proceedings. The refusal to appear before the international judicial body raises questions in the minds of many international lawyers and many governments around the world as to how you can reconcile this China's avowed commitment to an international order based on international law with China's behavior. This picture is the infamous photo taken at the scene of the South China Sea arbitration case. This is the picture of the oral hearing in that case, as you can clearly see. To the left is the table for the applicant in that case, the Republic of the Philippines. They have a large legal team present there. To the right should have been the Chinese team. And as you can see, you only have empty seats, some water cups, some papers on the table, and that's it. China's position in the South China Sea arbitration case raised serious questions as to China's real attitude towards international judicial dispute settlement. It also raises serious questions as to whether China will continue its non-appearance policy or practice in future judicial proceedings that other states might have brought against China. Now, as I said, today I will not address the areas of international trade, WTO, or international investment, ICSID arbitration. I will be addressing the areas of traditional public international law, territorial disputes, maritime disputes, human rights, protection of individuals, environmental protection, global health, jurisdiction and immunities, and so on. In those areas, does China's practice in the South China Sea arbitration case indicate a typical policy that China will continue to implement in future cases. Now, I will not actually speak to the South China Sea case too much here. My colleague and friend, Professor Michael Gao, I believe will be addressing the South China Sea case in much detail, and he is a real expert in that field. So I would pretty much leave that to him. I would here just quote this statement from the Foreign Ministry of China, which was issued in the wake of the merits awards of the South China Sea arbitration case. In that statement, the Chinese Foreign Ministry proclaimed, and I quote, "The Chinese government reiterates that regarding territorial issues and maritime delimitation disputes, China does not accept any means of third-party dispute settlement or any solution imposed on China." So that is clear. Territorial disputes and maritime disputes, China has made clear that third-party dispute settlement, including international judicial dispute settlement, will not apply. These disputes are off limits from the international judicial process. Will this attitude or will this position be applied to more broad categories of cases? That's something that I hope I can address at the end of my presentation. But before I do that, if you allow me, I would like to address the legal and practical issues concerning non-appearance or non-participation in international judicial proceedings in general. Now, in the interest of time, I do not plan to go into the history and the law of non-appearance in too much detail. What I propose to do is to start with a brief account of the history of non-appearance practice in international law, and then I'll address some of the salient legal and practical issues concerning non-appearance. I will then try to explore a number of policy issues. Why do states decide not to appear in international judicial proceedings? What are the advantages and disadvantages for states who do not appear in international judicial processes? On the basis of these discussions, I hope I can draw some conclusions for China, and I look forward very much to discussing with my colleagues here. Much of what I'm going to talk about really is just tentative and exploratory. I very much look forward to discussing with my colleagues in the panel, as well as the audience, and I certainly welcome your questions and comments. So, non-appearance. Well, non-appearance actually has a pretty long history. Many states have done it in the international judicial dispute settlement practices. The history of non-appearance, the history of states, usually the respondents or the defendants, not appearing before an international court or tribunal can be divided into roughly 3 periods. The first period was the early period before the Permanent Court of International Justice. Actually, interestingly enough, the first major international case of non-appearance also involved China. That was the Republic of China, who decided not to appear before the court proceedings brought against China by Belgium in the Belgium versus China case in 1928. Now, that case was quickly resolved by negotiation, so not much impact there. During the early period of the International Court of Justice, the present World Court, there were several cases of partial non-appearance, cases where the respondent states decided not to appear or not to participate in some of the phases in the judicial hearings. So you would have cases like the Gulf Channel case, the Anglo-Iranian Oil Company case, the Notre Dame case, etc. So you have some instances in the early history of the current World Court. The peak period for non-appearance really was in the 1970s and early 1980s. During that time, there were several major cases in which the respondent states practiced complete non-appearance. In other words, they decided to boycott the entire proceedings before the International Court of Justice. So these were some of the major cases. There was the fisheries jurisdiction case, Iceland not appearing, nuclear tests cases, France not appearing, Tehran hostages case, Iran not appearing, Aegean Sea continental shelf case, Turkey not appearing, and then of course the most famous of all, the Nicaragua case, in which the United States did not appear in the merits phase of that case. The US boycott of the Nicaragua merits phase happened in 1984. After that, however, there was quite a decline in the practice of non-appearance. That is to say, after 1984, after the United States poured that big drama in the Nicaragua case, all of a sudden, most states seemed to realize that non-appearance really did not make a lot of sense. And it was not really in their national interest that much. So after 1984, for nearly 30 years, there was not a major case in international courts or tribunals of non-appearance. That is until 2013, when China decided not to appear in the UNCLOS Annex 7 arbitration, the famous South China Sea arbitration case. And since 2013, since China started that, well, there seems to be a resurgence or a renaissance of non-appearance in international judicial practice. Since 2013, we now have quite a few cases. Some of those some of them are major cases before the International Court of Justice, in which the respondent states decided not to appear either in total or in part in the international judicial hearings. So I have here on the screen, well, 5 cases. This is not a complete list. There are a few other not so major cases, but these 5 are pretty well known. So the South China Sea arbitration case, China not appearing. The Arctic Sunrise case of the same year, Russia not appearing. The maritime delimitation in the Indian Ocean, Somalia against Kenya. This case was initiated in 2014. The International Court just handed down the merits judgment a few weeks ago, and that is the case in which Kenya did not appear in the oral proceedings of that case. And then there was the case concerning the arbitral award of 3 October 1899, Guyana against Venezuela. The case was initiated in 2018 and it is still pending before the International Court. Venezuela has decided not to appear in the entire proceedings of that case. And finally, we have the Jerusalem Embassy case. I think the official name of the case is the relocation of the US Embassy to Jerusalem. And that was the case of Palestine against the United States. The case also was instituted in 2018. And in that case, the United States under the Trump administration decided not to participate at all in that case. So we have quite a lot of cases in which the respondent states refuse to appear before the court. Sometimes they boycott the entire proceedings, sometimes they just fail or refuse to appear in part of the proceedings. And when you look at the states that did that, the non-appearing states, well, those states are quite varied. They fall within all kinds of categories. You have liberal democracies, United States, France, Iceland. You have authoritarian states, China, Russia, Iran. And then you have states, well, kind of in the middle, Kenya, Venezuela, Turkey. So it's not easy to draw general conclusions about the practice of non-appearance being the trait or being the practice of a particular political group of states. What is the legal implication of non-appearance? When a state refuses to appear before the international court, what will happen? Well, the statutes of major international courts and tribunals all have provisions dealing with the non-appearance by state parties. The most representative provision is Article 53 of the Statute of the International Court. I'll just go through this provision with you for those of you who are not familiar with this area of law. I will not obviously go into the details, but just to point out the important aspects of this law. So Article 1 of Article 53, sorry, Paragraph 1 of Article 53 says, wherever one of the parties does not appear before the court or fails to defend its case, the other party may call upon the court to decide in favor of its claim. All right, so Paragraph 1 makes it clear that a state not appearing before the court does not really stop the judicial process. The judicial process will continue to proceed to its conclusion. The court will still be able to issue a judgment in that case, even though a state decides not to appear before the court. That's Paragraph 1. Paragraph 2 says the court must, before doing so, satisfy itself not only that it has jurisdiction in accordance with Articles 36 and 57, but also that the claim is well-founded in fact and law. So that is to say, when a state fails to appear before the court, the other state does not really automatically win the case. There is no default judgment in the sense of domestic law in the international courts. What will happen is that the international court will need to do two things in its judgment. It will need to determine that it has jurisdiction, that's number one, and then it will need to determine that the applicant's claim, the claim of the appearing party, is well-founded in fact in law. Once the court is satisfied with these two matters, then the court will enter a judgment in favor of the appearing state. Now, in reality, when we look at the many cases of non-appearance that have occurred, in the overwhelming majority of the cases, the court has sided with the appearing party. In other words, non-appearance usually means you will lose the case. I think the only major exception to that phenomenon is the Aegean Sea continental shelf case, in which Turkey did not appear, but Turkey still won the case. That was, I think, a very rare exception. All right, one of the legal controversies in regard to non-appearance is whether there is a legal obligation to appear. When a state refuses to appear before the international court, has that state breached its international legal obligation? This question used to be controversial in international literature. There are divided views amongst international lawyers, and there are arguments against the obligation, and there are arguments for the obligation. At present, it seems to me that the prevailing view in the international literature is that there is no such obligation. Well, why is that? The arguments against the idea of obligation include, well, the following. First, it is often said that appearance is a right. You have a right to appear if you are sued, but you don't have an obligation, you don't have a duty to be there. Secondly, it is also said that when you look at those default provisions in the statutes of international courts, like Article 53, which we have just seen, Article 53 envisages non-appearance by state parties. So the argument here is that when you look at those default provisions, like Article 53, the implied meaning is that a state party may or has a right not to appear. It is okay if they do not appear. The international proceedings, the judicial proceedings will go ahead in accordance with Article 53. So that is the argument. Finally, it is often said that non-appearance may serve as a litigation tactic. Sometimes a state party may determine that it is in its interest not to appear before the international court. The arbitral tribunal in the South China Sea arbitration case, a unanimous award, made the following statement in regard to this last point, the point about non-appearance as a litigation tactic. This is from the Merits Award, paragraph 1180. I quote here, "China has been free to represent itself in those proceedings in the manner it considered most appropriate, including by refraining from any formal appearance, as it has in fact done. The decision of how best to represent China's position is a matter for China, not the tribunal. China is not free, however, to act to undermine the integrity of these proceedings or to frustrate the effectiveness of the tribunal's decisions." So as you can see, the tribunal here seems to be saying that non-appearance is a legitimate litigation tactic. It's in China's discretion or right whether or not China wants to appear in that particular case. Now, it says that you should not sabotage the integrity of the arbitration case. In that case, the tribunal later on would find that China did sabotage the arbitral process, but that's another point. So that seems to be the prevailing legal opinion now. Non-appearance is not really an obligation. It's a discretion. It's a legal right of a party to decide whether or not they want to appear. If you don't appear, fine. The court will still render a judgment. And if the judgment is against you, the judgment will be binding on you, and you still have the international legal obligation to comply with the judgment. But there, I think, still exists a strong minority view which argues that there is a legal duty to appear before the international court. In several non-appearance cases, for instance, we have counsels for various states who have argued on behalf of their governments before the international court that in their view, there is a legal duty to appear. Now, the arguments for that idea, the arguments for the idea of obligation include the following. First of all, it is argued that non-appearance will bring about impairment of administration of international justice. Well, obviously, a judicial process involves a conversation, a dialogue between the parties. You cannot have just one party speaking alone to the court. That essentially is not right. That's not what a normal judicial process is about. So if you agree to be a member of the international court, if you have joined a treaty setting up that international court, by implication, well, you should appear before the court if you are sued in the court. So that's one argument. The second argument is that non-appearance, or appearance rather, is required by duty to cooperate. When you are in an international legal system, when you are in an international legal regime, whether it's WTO or Law of the Sea Convention or the United Nations system, when you are in that regime, you have a duty to cooperate with the institutions in that system. And that duty to cooperate, by implication, requires you to appear before the court. And finally, in most, if not all, cases of non-appearance, the International Court or Tribunal will express regret whenever a state refuses to appear before the court. The expression of regret is an expression of disapproval. The most recent statement by the International Court of Justice on the question of non-appearance can be found in this judgment. This is the judgment on preliminary objections by the International Court in the case of Guyana against Venezuela. This judgment was handed down in December 2020. As I mentioned, Venezuela refused to appear before the court in that case. And this is what the court had to say regarding Venezuela's non-appearance. The court said, and I quote, "The non-appearance of a party obviously has a negative impact on the sound administration of justice. In particular, the non-appearing party forfeits the opportunity to submit evidence and arguments in support of its own case and to counter the allegations of its opponent." So here you can see that the court clearly is indicating an attitude of disapproval regarding non-appearance. And the court is indicating, it is saying that actually non-appearance is not really in your interest. So that takes us to the next question. If it is true, as the court indicated here, non-appearance usually is not a good thing for you, and if, as we have already seen, in most cases of non-appearance, the non-appearing state will lose the case. If that is all true, why do states not appear? What are the reasons? What are the causes that states decide not to appear before an international court? Now, in most, if not all, cases of non-appearance, the official legal reason why a state decides not to appear is because they say, according to them, the court has no jurisdiction. Or in other words, they have not consented to the international judicial process. And that is almost always the official reason why they do not appear. But when you look at various cases, when you look at those many cases of non-appearance, it would seem that the real reasons that the court, that those states decided not to appear have been quite varied. There are all kinds of motivations that have been at work in those many different cases. So for instance, let me just go through some of the reasons that I have summarized. I'm sure my colleagues may come up with some other possible reasons. But for instance, in many cases, states decided not to appear because they consider the disputes to involve some core interest of those states. Put another way, they consider those disputes or issues to be non-justiciable, not suitable for international judicial resolution. That certainly is part of the reason why China did not appear in the South China Sea case, because the South China Sea, the territorial maritime issues in China's view, is not to be litigated. It concerns China's core interest, so it's out of bounds. It's off limits for international courts. Another reason that has been documented is often states do not have confidence. They have strong skepticism in regard to the international judicial institutions and the international judicial process. They are concerned that international judges may be biased, that they are concerned that the international judges may not have sufficient sympathy or knowledge about their positions. That certainly has historically been one of the major concerns of China as well as many other developing countries. Still another reason is that sometimes states have a lot of confidence in the strength of their case. They think the strength of their case is so self-evident that they don't need to present the case before the court. Well, that sometimes happens. So for instance, in this recent case involving the United States and Palestine, the United States under the Trump administration decided not to appear before the International Court after Palestine initiated the proceedings, because the United States apparently thought that their argument against Palestine was so strong that they do not even want to appear before the court. That, if you will, is a very typical Trumpian attitude. But more often, here's another reason, more often states do not appear because they lack confidence. They lack confidence in the strength of their case. They know or they fear that their positions are not really very well supported in international law. In regard to the South China Sea case, even though the Chinese government does not officially say it, officially they say the completely contrary position. But if you talk to many international lawyers and even diplomats in China in private, many express concerns, very grave concerns, about the strength of China's case in regard to the South China Sea. And still another reason is that sometimes states do not appear just because of mismanagement. That seems to be a strong reason why Kenya, for instance, failed to appear in the oral proceedings before the International Court in that case with Somalia. Sometimes states just did not have experience, expertise. They did not manage or prepare properly. They missed deadlines. They could not get their legal team together. And just as a matter of misadministration of their case, they failed to appear before the International Court. That seems to be the case in some instances. Well, when you have non-appearance, what are the advantages and what are the disadvantages? And here I give you, again, these are very tentative points that I put to you. And I should say that these points are very much open to discussions. What are the advantages if you do not appear? Well, the advantages of non-appearance, here I give you legal, political, diplomatic, moral, and administrative advantages. What is the legal advantage? Well, the legal advantage for a non-appearing state is actually quite well documented. Many lawyers have argued that when a state refuses to appear, it puts a lot of hardship, a lot of burden on the other side to make a proper argument. Now, when the other side is not there, it is always quite challenging for you to present your own case. So in the South China Sea arbitration case, for instance, China did not appear, and that means the Philippines and the tribunal itself will have to address all possible bases of China's objections. Since China did not officially make objections to the court's jurisdiction, the tribunal and the Philippines will have to canvass all possible objections. And that really puts a lot of burden on the other side. So that's a legal advantage for the non-appearing state. The political advantage is that when you do not appear before the International Court, you are in effect politicizing the dispute. You're sending the message mostly to your domestic audience, but also to the international community. You are saying that the legal aspect of this case is really secondary. You are drawing people's attention to the political, to the historical, to the socioeconomic aspect of that case. You are trying to highlight your concerns, your grievances, your positions in regard to the extra legal aspects of the case. So in other words, you are switching people's attention away from the legal aspects of the case. And that can sometimes work in favor of the non-appearing state. The diplomatic advantage is often a posturing. When a state indicates that it is not going to appear before the international court, it is sending a strong message that it means business, that it is taking a very tough stance on that dispute, and it is actually threatening or deterring other states who may try to take further actions. After the South China Sea case, of course, many people were talking about whether Vietnam or other states may bring similar proceedings. So far, this has not happened. Why? We don't know. But part of the reason may be this very strong diplomatic message that China has sent through its non-appearance. Moral advantage, well, that is really an effort to delegitimize the international judicial process. When you do not appear before the court, you are saying this court is not legitimate. We do not give any credibility to this court. That can play in a way to the moral benefit of that party. Finally, administrative benefit. When you do not appear, well, you don't have to run the risk. The bureaucrats, the government officials who are in charge of this dispute, well, they don't have to do all the work preparing for the case. Right? Preparing for the case is hard work. And there's also the risk of losing the case, which bureaucrats typically want to avoid. So especially for states who do not have experience or expertise in those cases, non-appearance could bring administrative benefits, especially for those bureaucrats in charge of the dispute. What are the disadvantages? I suppose the disadvantages should be quite obvious. When you do not appear, you have legal disadvantage, you probably will lose the case. Political disadvantage, you're going to suffer a huge loss of your international reputation. You will be seen as an international outlaw. You will be seen as not showing good faith to international legal obligations. You will also suffer moral disadvantages on the issues on which the tribunal or the court has decided. It will be very difficult for you to try to assert your position in the future because you will be at a huge moral, if not legal disadvantage to try to maintain your position if a court or tribunal has decided against you. Practically, if you lose the case, well, you will not respect the judgment, that's fine. But in practice, in most cases involving non-appearance, what we actually have seen is that sooner or later, after a while, the non-appearing state will come to terms with the judgment. Maybe they will not accept the judgment in rhetoric, but in their behavior, in the cases in the past, what we have seen is that often states will adjust their course of action in line with the judgment. All right, finally, will non-appearance be the new normal? Now here, I refer to this China's famous policy in the wake of the South China Sea arbitration, which is the so-called 3 no's. This 3 no's is no appearance, no recognition, and no compliance. No appearance, no acceptance, and no recognition. This was made clear in PRC's statement in 2016 on the South China Sea Awards. China solemnly declares that the award is null and void and has no binding force. China neither accepts nor recognizes it. This 3 no's policy, this non-appearance probably will be China's norm, will be China's policy in regard to territorial and maritime disputes. Now, in regard to other legal disputes, other public international law disputes, will China also adopt a similar 3 no's or non-appearance policy? Now, I think as we have already seen, non-appearance has advantages and disadvantages. So I would expect the Chinese government to carefully weigh the pros and cons, the benefits and detriments in each particular case before they decide whether or not to cooperate and to appear. But with the current momentum towards the so-called wolf warrior diplomacy, that certainly does not inspire any confidence in China's giving sympathy to the international judicial engagement. All right, that's all that I want to say. Thank you very much. Thank you, Jiang Yu. I give back the floor.
Thank you very much, Professor Ling, for the very exciting presentation. As always, both provocative and inspiring. I myself do have a lot of questions, but let's follow our normal procedure. And let me first invite Professor Michael Gao to have his comments. Professor Gao, are you there? You are muted again. Are you?
Yes, I'm here. Can I share the screen?
Yes, sure. You can share the screen.
So I would like to go deeper in the case of the South China Sea arbitration, and to kind of substantiate what Professor Ling Bing has just said. The brief comment of my presentation or my comments is entitled "The Roles of Taiwan Authority in the South China Sea Arbitration under China's Non-Participation." I just want to address two different roles of Taiwan Authority on the theater of South China Sea arbitration. The role number one is defining the rights passed on the PRC by succession, the government succession in 1949. The role number two is to deviate from or superseding PRC's positions. Now, the role number one, which is defining the rights passed on the PRC by government succession. Well, actually, Taiwan was given a role in the South China Sea arbitration by the tribunal's question for the Philippines on 16 December 2014, after China refused to submit its counter memorial by the deadline. The tribunal provided the Philippines with request for further written argument by the Philippines pursuant to Article 25, paragraph 2 of the Rules of Procedure with 26 questions. Well, there's question number 15, which concerns Taiwan. It reads, China's claims to sovereign rights and jurisdiction and to historical rights with respect to the maritime areas of the South China Sea encompassed by the so-called 9-dash line are contrary to the convention and without lawful effect to the extent that they exceed the geographic and substantive limits of China's maritime entitlements under UNCLOS. The Philippines is invited to comment on the relevance, if any, to the interpretation of the 9-dash line of the remarks of the President of Taiwan Authority of China, Mr. Ma Ying-jeou, on 1st September 2014, on the occasion of the opening ceremony of an exhibition of historical archives. Well, it goes back to 1947 about the location map of South China Sea Islands published in that year by the Republic of China government. Well, actually in 1945 and 1946, the ROC government recovered Taiwan and the South China Sea Islands from Japan respectively. In 1947, the ROC government issued the location map, or the Nanhai Zhudao Weizhitu, using U-shaped line or 9-dash line to embrace Taiwan and the South China Sea Islands. However, Taiwan was never considered as South China Sea Islands. The location map represented ROC's territorial claim over the islands within the U-shaped line or 9-dash line, as indicated by the title of the map. The map did not indicate the nature of claims made by China then over the waters within the U-shaped line, apart from territorial sea surrounding the islands within the U-shaped line. Now, Going back to the question from the tribunal to the Philippines, judging by the nomenclature, that is Taiwan Authority of China, and the formulation of the question, Taiwan was seen by the tribunal as part of China instead of a separate state. Besides, the government of Taiwan or Taiwan Authority can only be a provincial government of China. Throughout this arbitration, the tribunal had addressed the PRC government as the representative of China. Therefore, Taiwan cannot speak for China or act on behalf of China in this case. Why then does the statement of Taiwan Authority's leader matter? The answer is actually implied by the tribunal's question. The Philippines is requested to comment on President Ma's interpretation on the 9-dash line drawn by the ROC government before leaving the mainland and ceasing to represent China. That occurred on 1st October 1949, when the PRC government prevailed in the Chinese Civil War. The ROC government survives in Taiwan ever since, becoming Taiwan Authority. Given the PRC's non-appearance in the South China Sea arbitration, the tribunal seemed to find the Taiwan Authority willing and qualified to interpret China's, that is, its own actions in 1947. The Philippines shared these positions. On 25th November 2015, that was the second day of the merits hearing of this arbitration, one of the Philippines lawyers, Mr. Lowenstein, answered a question from Judge Wolfram, that is one of the 5 arbitrators of this case. Judge Wolfram's question was whether one can distinguish between the ROC or Taiwan and the PRC. Mr. Lowenstein replied, the Philippines considered that there is only one China, and it is the PRC. It is the People's Republic of China. Since 1949, only the People's Republic of China has been able to speak for or on behalf of China. The actions of predecessor government prior to 1949, including the PRC, which is now based in Taiwan, are, of course, attributable to China as well. The actions of the Taiwanese authorities since 1949 are not per se attributable to the PRC. The above statements fully characterize Taiwan Authority's role in this arbitration. First, in principle, Taiwan Authority after October 1949 cannot speak for and on behalf of China. Since that time, it was the PRC that has exercised effective control over the mainland and therefore become qualified to legally represent China. Secondly, before October 1949, the PRC government, now Taiwan Authority of China, was the representative of China. The positions and claims that government had made then in and for the South China Sea, including publications of the 1947 location map containing the U-shaped line, were attributable to China. They became the legal and political heritage passed on to the PRC in October 1949. Third, exceptionally, after 1949, Taiwan Authority can still speak for and on behalf of China, provided its positions were meant to interpret what the ROC had done before October 1949 concerning the South China Sea territorial and maritime claims. Fourth, even so, Taiwan Authority can speak for and on behalf of China, provided that it remains Chinese or being of China. It must identify itself with the pre-1949 ROC by complying with the 1947 ROC Constitution with territorial claims covering Taiwan, the mainland, and the South China Sea. Fulfilling all these conditions, perhaps the remarks of Taiwan Authority's political leader can be relevant for the South China Sea arbitration. On 15th March 2015, the Philippines provided the answer to question 15. President Ma's speech on 1st September 2014, viewed by the Philippines, negated the historicity needed for historical rights, including historical titles, to be claimed beyond the territorial sea surrounding those maritime features indicated on the 1947 location map. President Ma's interpretation presented by the Philippines was as follows. President Ma correctly observed that at the time China published the map, the concept of the territorial sea was 3 nautical miles, and that if there was smuggling, the Chinese authorities would try to capture the smugglers at twice the distance, or at most 12 nautical miles. There was, as President Ma put it, no claim at all on other so-called sea regions. Some comments, that is the Banyan column on President Ma's remarks, was published on 4th October 2014 by The Economist magazine. 1 month later, on 1st November 2014, Mr. Liu Zhigong, who is the representative from Taipei in the United Kingdom, dramatically published a profound clarification in the same magazine, correcting the October article. This clarification strongly implied that the ROC claimed historical titles within the U-shaped line in 1947. Now, here I quote, Taiwan and the South China Sea, sir, in response to the Banyan column, which is joining the dashes, October 4th, I would like to clarify the position of the Republic of China, Taiwan, on the islands in the South China Sea. When President Ma Ying-jeou spoke last September at the opening ceremony of the exhibition of historical archives on the ROC's southern territories, he stated that when the ROC reclaimed and announced its sovereignty over the islands and their surrounding waters in 1947, the law of the sea existing at that time did not provide for maritime regimes other than territorial seas and contiguous zones. President Ma did not say that the ROC's claim was limited to the islands and 3 to 12 nautical miles of their adjacent waters, since the location map of the South China Sea islands published by the ROC government in 1947 covers both the islands and their surrounding waters. According to Representative Liu Zhigong's clarification, President Ma did not mean to say that the China's maritime claims in 1947, as demonstrated by the location map, was confined to the adjacent waters of the South China Sea islands, which were 3 to 12 nautical miles, that is territorial sea and anti-smuggling zone. This rejected the comments of The Economist magazine published in October. Representative Liu Zhigong then explained that in 1947 location map covers the ROC's maritime claims beyond 12 nautical miles because the map covers both the islands and their surrounding waters. Seen in the context, the term surrounding waters must be first, different from adjacent waters, second, consequently wider than 12 nautical miles, and third, of the legal nature other than territorial sea and anti-smuggling zone. The ultimate question comes, where does the surrounding waters end? As clarified by Representative Liu Zhigong, President Ma stated that the ROC reclaimed and announced its sovereignty over the islands and their surrounding waters in 1947. It reminds us of the U-shaped line appearing on the 1947 location map that surrounds the South China Sea islands as a boundary. Possibly, the surrounding waters over which the ROC reclaimed sovereignty are the waters within the U-shaped line, if considering the South China Sea statements made by Taiwan Authority later. To be noted, the statements of President Ma and Liu Zhigong were all made, published and commented before 16th December 2014, when the tribunal's questions were posed to the Philippines. Unlike President Ma's speech, Liu Zigong's none less important clarification were shelved by the tribunal and the Philippines. Now, here is the role number 2, played by Taiwan in the South China Sea arbitration, that is deviating from and superseding PRC's positions. The South China Sea arbitration gave Taiwan Authority another role to play that amazingly crossed the Lowenstein's line. On the second day of merits hearing, Taiwan Authority's position not aiming at interpreting its pre-1949 positions while undermining the PRC's positions was taken by the Philippines as attributable to and representing China. In that morning, Mr. Reckler, who is the chief lawyer of the Philippines legal team, informed the tribunal of the following China's position. China claims sovereignty not only over the 3 high tide features that its armed forces occupied, that is Fiery Cross, Carteret, and Johnson South Reefs, but over all the rest as well. However, it has never asserted that any of these individual features generates an entitlement beyond the 12 nautical miles territorial sea under Article 121 of the UNCLOS. And it has never argued that any of them is capable of sustaining human habitation or economic life of its own. Instead, China has simply claimed in general terms that it is entitled to a 200-mile EEZ and continental shelf from the Spratly Group as a whole. Mr. Reckler then switched to a different position of Taiwan. That leaves only Taiwan as claiming entitlement to a 200-mile EEZ and continental shelf for any of the individual Spratly features based on Article 121. Taiwan's claim in this regard is expressly limited to Iduaba. Mr. Reckler continued to present evidence published by Taiwan on 7th July and 31st October of 2015 about Iduaba as a fully entitled island. Such positions of Taiwan Authority were neither made before 1949 nor intended to interpret any pre-1949 ROC conduct. Such positions differ from and undermine those of the PRC, that is, claiming maritime entitlements from the Spratly Islands as a single unit. Obviously, Mr. Reckler's statements went beyond the Lowenstein line that confines the Taiwan Authority's role to defining the rights passed on the PRC in 1949 by succession. Now, here I will stop here. This is the 2 roles I found played by Taiwan Authority in the South China Sea when China refused to appear. Thank you.
Well, thank you very much, Professor Gao. This is actually a second seminar. So I consider that as actual benefit for me and also for the audience in general. I would like now to invite my colleague, Dr. Fuzia Long, to share her insights. Fuzia, please.
Thank you very much. Thank you, Juan Yu, for giving me this opportunity to listen to this wonderful presentation and of Professor Ling and of course Professor Gao. It was definitely a learning curve for me. Now, I think that I have some comment generally and some things to say, so I'll just go on and do that. I think that the presentation of Professor Ling raised very interesting queries regarding the Chinese engagement with international legal settlement disputes. And of course, what is the non-compliance in that context mean? I think it was generally not just focused, although it did mention a lot about China, but when we talk about non-compliance and we talk about other state attitude, is very much similar. For instance, if I had a blood taking today, just to let you know, and I fainted, and it would have been a non-appearance by default. So the question is this: I would say that because just to clear my position, I am a third world approach to international law, and also to the new, I am a New Haven scholar partly. So I would like to mention to start with that the state is a legal construct, in my view. It's, states behave exactly the way the individuals will behave. Making decisions based on their experience, their interests, and of course the principles. So clearly, humankind makes decisions on case-to-case basis. And in that respect, if we look at China's approach towards a dispute settlement, I wouldn't say it's any different. Although it's true to say that China progressively is ready to accept the adjudicative methods of dispute settlement when it considers the benefits of doing so. And it says that, well, if the economic and political benefits are better, and humans will probably do the same. So, and in that respect, China, as I said, is not different from human beings and not different from other states as well. So, it's a known fact, as Professor Ling correctly mentioned, that whenever the issues of sovereignty are involved, China has not adhered to it. So of course, it has selectively adhered to or rejected the jurisdiction of the international law to the extent it was useful to it, and it has accordingly acted. And China has not accepted the ICJ jurisdiction under Article 36(2) of the ICJ statute. And that to a large extent raises questions about the applicability, and maybe Professor Ling can say more about it, about the applicability of Article 53 of the ICJ statute. Because Article 53 of ICJ statute, I'm not really sure whether it applies to only contentious cases, right? And obviously, if China is not appearing before the court, then the question arises that how does that apply to it? And then the second question that I have, in relation to the ICJ, in relation to the South China Sea disputes that Professor Gao as well as Professor Lin mentioned, I have a question about it, and Professor Lin mentioned about the Taiwan's authority. So again, the question would arise that to what extent is Taiwan seen as an agent of a PRC, and whether they will be in a position to make remarks like that. So clearly, where issues of sovereignty are concerned, and I do a lot of work on the Sino-Indian border disputes. So the question arises that China is generally obviously hostile to it, because clearly it doesn't see it as beneficial for it. So it's strong. It has a strong preference for the political or diplomatic approaches in that context. But the question then arises that has China completely rejected the ICJ jurisprudence in international dispute resolution? Now, well, generally, when we talk about the WTO and other places, China has demonstrated clearly a productive engagement with international law on a selective basis, as I mentioned. And clearly, whenever they have more political, will to do that, they will do it. And that we have seen in South China Sea dispute case. And clearly, when China did not engage with the or they did not appear, there's a non-appearance in that respect. But then they published this white paper, which actually clearly mentions what are their concerns, what are the positions, at least for the CSC situation. So would that be then seen as a sort of an offline sort of engagement with international law, although it is not by appearance, but it is by taking pains to publish these long papers whereby they actually try to mention what their positions are. So to what extent that could be seen as obviously an engagement short of non-appearance. You see, this is non-appearance clearly, but it is also sort of an engagement. But if you look at the unit clause, under the unit clause, they have already opted out in 2006 for the compulsory settlement procedures under the unit clause. So clearly the question is that, again, can we see the situation as a clear non-appearance in that respect? Because they're not party, they're not ready to accept the compulsory settlement procedures. And then if you talk about the generally taking it a further up and talking about in China not actually participating or like non-compliance, but China has actually been prepared to support some of the international criminal courts and tribunals when there are like parts of, especially ICC, for example, although it's not party, but it has explicitly ruled out to be the party of ICC, but clearly it has been engaged in its formation. And China has also been voted in favor of the ICTY and ICT, I think ICTY clearly. So there also one could see that whether that could be a sort of an in interest to engage, but clearly when they are provided the clear playing field, if you like. So the Chinese attitude towards international dispute settlement, like in many other Asian countries, like India, for example, it is evolving towards greater acceptance, if you like, and engagement. They want to engage and accept. But of course, when we talk about a very narrow topic of non-appearance, then there could be, we have to also think about the non-appearance in two different ways. It's a complete non-appearance, which is also called default, and then sort of a partial non-appearance. Now, I'm not really sure the behavior of China in this respect, where does it actually clearly fall, because they want to clearly engage, but they don't want to appear. And you have clearly mentioned the advantages and disadvantages of that, because advantages clearly that, you know, is not binding on them. If they appear and then they lose, they have this, I think at this point, I would also like to bring to the discussion the Chinese history as well. You know, the Chinese history about the interaction with colonialism and imperialism, and that's where these fears are coming from, because they see these international institutions as Western creation, if you like. And they have a fear, if you like, that they might go against them. They might decide things that that will, you know, will not be beneficial for China. So there is clearly the strategy of selective adherence to international law settlement disputes. For example, in China, India, like, because I work on it, so I can say more things about it. So in China-India border disputes, China is willing to engage, but they do not accept the colonial lines that were actually, you know, drawn at a time when China was less sort of powerful and was under imperialism, and they did not want to accept those lines. For example, McMahon line, but they are still willing to participate in the discussion. They're willing to take into consideration the other side's concerns. And we have seen that very recently when there was this standoff in Galvan Valley in 2020 in May, and the things that happened on both sides. And China's approach in that way was to sort of de-escalate the matter rather than to escalate the matter. So one has to take into consideration all these things, because when we talk about just the law, international law, it's very objective. It is a black and white letter law. It does not take into consideration the subjectivities, but certain subtleties, taking into consideration such subtleties, in my view, are quite important. because if we want a country, whether that's China or any other country, to engage with the international courts and tribunals, those courts and tribunals must be perceived as legitimate and capable of offering states the level playing field. Is very important, because otherwise they will not engage with it. And there are different ways, and China is not alone. US is not party to, for example, ICC. US has many times not appeared in cases that, like mentioned you, Nicaragua. But then again, I think there's two different things here. One thing is that where we take a refuge under the international law, where we say that, well, we're not party to a particular, tribunal. For example, let's talk about ICJ. China is not party to ICJ. It has not accepted the compulsory jurisdiction under Article 36(2), and that's a very easy case to say. But as you rightly mentioned, countries have the duty to cooperate as well. That's a subject to sort of it's a duty, but of course, to what extent the states will abide by these duties, well, they have to also consider their own interests. So how do they balance these two things? So clearly, in such a situation, I think that it is not only the duty of the state to do certain things, but it is also the duty of the international community to encourage each other and create a system, create an atmosphere, create a place, circumstances that will give countries a sense that there could be a justice for them as well. So it should be really, as I mentioned, it should be more legitimate and capable of offering states that kind of sense of legitimacy. So I think that over the years we have seen a gradual shift in China's attitude as well. For example, China is now, because they understand, for example, let's talk about the environmental issues, and we see that in environmental way that they have actually signed certain agreements, like the Paris Agreement, for example. So they are willing to. So I think that the most important thing also is that as the problems occur and they start to affect the states, they will start to act on it as well. And that's an example of that, because China is more actually now involved in, as I mentioned, in environmental, and they have signed this Paris Agreement. So clearly, when these things happen, the states will also, apart from whether that is beneficial or not beneficial, they will actually act on it. So all in all, I think that your presentation I really, really enjoyed and learned quite a lot from it as well. But the question still remains, considering the Chinese attitude towards the international law and relations, the question arises that to what extent will China actually keep this position of non-appearance one way or the other, and try to appear in a way diplomatically, because as in the South China Sea dispute arbitration, they had white paper published in 2014, and I would think in certain ways that was a way to engage, that was a way to express their own views and positions on that, and whether that would be a new normal every time this happens, and they would probably publish a paper. But again, I think that some of the things that what is also important is that because Chinese in China they don't have, I mean, at least I'm an outsider, I'm not Chinese, but from what I see and read is that the skills is also very important. Maybe is it China in a learning phase where they will first of all try to engage with the international community through these white papers, and then there would be a time where they would just appear. So I don't know. So we have to wait and watch. So thank you very much. Thank you, Professor Wang again, and Professor Ling Bing is amazing, and of course Professor Gao. Thank you.
Thank you very much. Thank you very much, Fauzia, for the wonderful comments. I am the chairperson, but I am also supposed to be the third discussant. I will be very brief. I will basically play the role of the devil's advocate. As always, this is basically the nature of the conversation between Professor Ling and me. In the past few years, since we became friends, we always argue with each other, and that's why we have actually we have a closed-door international law forum, so for us to quarrel with each other. So I will make three comments here. So the first one is, it looks to me that if a country receives, if non-appearance is based on the ground of no jurisdiction, that is actually a very technical legal issue. So there's nothing wrong with it. And if a tribunal does not even have jurisdiction, which means it doesn't have there's no legitimacy for the tribunal to try the issue. So if a state protest or does not participate in a legal process based on non-jurisdiction, then all those criticisms about the advantages, disadvantages, especially the disadvantages about non-jurisdiction, probably about non-experience, probably don't apply. So that's my first point. My second point is so as for whether any form of new normal is appearing or has appeared. So I think it's probably too early to jump to any conclusion. We don't have conclusive evidence. If we are talking about non-experience, in general, in international litigation for the whole world, Professor Ling did mention a few cases of non-appearance. So seems the non-appearance seems to be the play in the town, but the size of the sample is still too small to come to any conclusion about whether non-appearance will be the new normal. Non-appearance is related to quite a lot of factors, including the general geopolitical environment, which is becoming actually very bad these days. But for regarding China in general, the Chinese approach to international dispute resolution is an evolving process. Right? It's an evolving process. But it's quite clear that China has always been of the view that sovereign states should be able to choose the means of dispute settlement rather than being subject to compulsory jurisdiction. So China is actually quite selective in this regard. As Professor Ling mentioned in the beginning, China is much more friendly to international trade and the investment dispute settlement, but China has been rather persistent, has been rather dogmatic on its position that territorial disputes, sovereignty-related disputes are not to be subject to compulsory jurisdiction. And the Chinese position in this regard has been rather consistent, as evidenced in the statement of the PRC Ministry of Foreign Affairs mentioned in the presentation slides of Professor Ling Bing. So if this, on China alone, it's not a surprise to predict that at least in the foreseeable future, although the Chinese approach is the evolving one, but in the foreseeable future, even without any elaborated study, we know that China is going to do that. So it's not only a new norm, it is the norm. So the question is there anything new here? That's my second comment. So my third comment is, speaking of the reputational costs, I do agree, I strongly agree that, so sometimes, for example, China's non-participation in the South China Sea arbitration was very much a reputational loss. But if we don't hold a double standard here, if we also apply the same standard to the US, because you said reputational cost is that you are viewed as the international outlier, no respect for international law, and a rogue state, those kind of things. Then the question is, does the same criticism also apply to the US, given that the US non-appearance in the Jerusalem embassy case recently, and also many years ago, in 1980s in the Nicaragua case, right? So the U.S. has been regarded as the vanguard of international law, of the international system, but the U.S. non-appearance seems to be rather is even more than China, because China has one case and the U.S. has several cases, right? Should we apply the same criticism, such as international outlier of international law, international outlaw to the U.S. as well? So those are my comments for Professor Ling's presentation. I also have a question for Professor Gao. Since you successfully resumed the debate, the already diminishing debate about the South China Sea arbitration. So I'm actually asking a technical question. What's your view about the legal significance of the non-dash line? You wrote about it, but I'm just curious about whether there's any new development in your thought about it. So I will give Professor Ling a chance to respond to the comments, and also hopefully Professor Gao also answer my question. Then we open the floor for questions. Professor Ling.
Yeah, thank you very much. Thank you to all the discussants for very valuable comments. Let me just address some of the points that have been raised very quickly. I think Professor Gao raises very interesting issues that are very complicated. It's not just a complicated political issue regarding Taiwan's role in the South China Sea disputes, but in terms of Taiwan's role in this international legal process, when you have Taiwan controlling the largest island in the Spratlys, and Taiwan asserting the identical 9-line or 11-line claim in the South China Sea, and when you have essentially an autonomous government in Taiwan, China's decision not to appear before the tribunal in that arbitration case will have impact on Taiwan's legal and practical position. So what is the role that Taiwan can play? And I think this is it's a very interesting and a highly complex question, and I'm very happy to hear Professor Gao's views on that. Regarding Dr. Nazir's comments, let me just address one thing. I think one of the things that Dr. Nazir very aptly pointed out is this historical trajectory. China historically has been very concerned about the neutrality, the fairness of international legal process. China has this strong reservation about whether this international court, whether it's the court in The Hague or the tribunal in Hamburg and so on, whether that could ever work in China's favor. But this seems to be changing, especially in the past 20 years or so. China obviously is increasingly engaged with WTO, with investment arbitration, and China is appearing before the International Court of Justice, not in contentious cases, but in advisory cases, right? So in many ways, this South China Sea case of 2013 really marked a watershed. It's a watershed moment. Does it have long-term significance? Does South China Sea case indicate that China will take a non-cooperative, non-participatory position with regard to international courts? I think Zhang Yu also mentioned it. We don't really know at this moment. We don't really know. One thing is because there's not much of a chance to test it, because whenever China joins an international treaty, China usually will just exclude itself from the compulsory court jurisdiction under the treaty. So there's not a lot of occasion for the International Court of Justice or International Tribunal for the Law of the Sea to have jurisdiction over China. Most of the cases we just cannot bring against China. But recently we have seen that there are some treaties like the UNCLOS, the Law of Sea Convention, and some international treaties under which it is possible to start a case against China, and it is possible to make out a plausible case of the clause jurisdiction over China. I think last year, the international legal community was talking about the possibility of suing China before the International Court of Justice under the WHO treaty. That is actually a possibility. What would China's attitude be? I think these are important but difficult questions. What I'm suggesting is that will China not appear? I mean, non-appearance necessarily leads to non-compliance, right? When you do not appear, you probably will lose the case. And when you decide not to appear, you probably have already decided not to comply, right? But non-appearance is a complex decision, right? As I hope I just demonstrated, there are advantages and disadvantages that the decision maker needs to think about. Finally, just one response to Zhang Yu's point, which is jurisdiction and legitimacy. Now, international court's jurisdiction is based on the consent of states. So you do not agree to the court's jurisdiction, then you cannot be sued. The court has no legitimacy in imposing jurisdiction on you. But if someone sues you, in the case of UNCLOS, the Philippines sues China, whether or not the court has jurisdiction, that is a question for the court to decide or for the tribunal to decide. It is not a question for China to decide or the Philippines to decide. That jurisdiction or that power to decide whether or not the court has jurisdiction, that is the inherent power of the court. This is the so-called compétence de la compétence. This is the jurisdiction to decide on jurisdiction. And it is well established, right? When China or other states do not even recognize the court's power to decide on its own jurisdiction, there's really no legal justification for that. Now, there may be political and strategic considerations in that, but legally there's just no jurisdiction. United States and many other countries do that as well. Is there reputational cost for them? Sure, there is, right? The Jerusalem embassy case, it's still pending. It actually is moving on very slowly. Now with Biden administration, will the United States change its course? I think remains to be seen.
Okay, great. Very brief and precise. Professor Gao, would you want to answer at least my question?
Your question is so complicated. You asked about the legal significance of a U-shaped line, right?
Yeah.
U-shaped line, cross Taiwan Strait relationship. The definition or the definition of U-shaped line, or the what U-shaped line means for mainland China and for Taiwan are not necessarily the same. Well, there are something that are shared by both sides. That is the territorial sovereignty over the maritime features within U-shaped line. So both Beijing government or both PRC government and Taiwan Authority claims territorial sovereignty over all the islands within the 9-dash line. That is 4 groups of islands. So that's something common. But you might want to notice that Taiwan's authority has evolved, has slightly changed its claim for the territorial claims on the maritime features. at the later stage of the South China Sea arbitration, and the new president elected in 2016 in Taiwan, the territorial claim over South China Sea islands are limited to Iduaba. So now, for now, the Taiwan government kind of refrain from claiming maritime features except for South China, except from Iduaba in South China Sea within U-shaped line. So that is point number one. Point number two, the claims for waters. Well, we all know that there's a basic principle under international law: land dominates the sea. So if you claim all the island groups, 4 island groups within the U-shaped line, then of course you claim the maritime zones generated from these 4 groups of islands within the U-shaped line. But now the issue is the South China Sea arbitration addressed the issue of the possible claim of using individual maritime features to claim maritime zones. But Chinese government, the Beijing government, refused to follow this kind of line. Beijing government is actually using the Spratly Islands, the Paracel Islands, as a single unit to claim territorial water, EZ and continental shelf. And for this kind of maritime claims, Taiwan authority appears to be different from the Beijing's government's position, because Taiwan government used Iduaba to claim EZ. And then thirdly, the maritime jurisdictional claim beyond UNCLOS, that is under customary international law, or what we say the historical rights. Here, Taiwan's claim is much more ambitious than Beijing. In the paper I published in the 五大边海院边界与海洋研究, in that paper I detailed a series of Taiwan's government's official documents demonstrating the Taiwan's claim over the entire water within U-shaped line as the historical water, or in other words, or the historical title in the technical terms of the South China Sea arbitration. But Chinese government has never applied the historical rights claim in the South China Sea until after the release of the 2016 award. So before July 2016, Chinese government did not specify that in the South China Sea, Chinese government has or enjoys historical rights. But on the day of losing the arbitration, Chinese government claims that the state of China enjoys historical rights in the water in the South China Sea. So in the Beijing part, historical rights. In Taiwan, historical waters. So these two are different. So this is my very brief answer to your question. But well, actually, it's more complicated, but there's no time. Thank you.
Of course. Thank you, Professor Gao. If I may ask for a very quick clarification, since in the South China Sea arbitration, the tribunal decided that Taipingdao is not an island, so it's not entitled to EEZ. So has the Taiwanese authority, has the Taiwan government to change its claim since then?
No.
Okay.
No.
Sure. Thank you very much. Now we open the floor for questions. I see from the names of the participants quite a lot of very familiar names of international law scholars, especially young international law scholars. Do you have any questions? Please speak up. And I can see from the chat box 2 questions by Mr. Raymond Gao. Mr. Gao, your questions are very long. Do you want to raise the question yourself? Are you still there, Mr. Raymond Gao? Or I can do that on your behalf. If you can, Professor Ling, can you read the chat box for the questions? Mr. Gao's audio is not working. So I think it looks to me that he has 2 questions. First, is China's non-participation in the South China Sea arbitration that unique among all countries in public international law adjudication? Or is it just the great power that great powers like to claim an exceptionalism to international law when their core national interests are concerned? So the U.S. Nicaragua case, I'm not sure whether this is a question or a comment, and maybe both. Professor Ling, would you want to respond? That's actually a very old question.
Yeah, it's well, is it unique? Well, it is unique in the sense that that decision not to appear by China was the first one, major one, in about 30 years, right? As I just said, for about 30 years in the international community, people always appear for about 30 years. So that was the first major case. And that then well, essentially started this recent resurgence of non-appearance. Does that mean, I mean, is that symptomatic of power politics, states never agreeing to judicial control when the case involves their core interest? I think yes and no. There are cases in which states agree to submit to international adjudication cases involving their important territorial or maritime interests. There are many examples of that. But it is also true that United States, for instance, does not even join the UNCLOS Convention. So you can never sue the United States in the UNCLOS system. And many states, especially important big powers, also carve out major exceptions to international court jurisdictions. In other words, excluding the international judiciary from their major interests. The reasons for that, I suppose, is quite complicated, and it's varied from state to state. As far as China is concerned, well, I think China has made clear that territorial maritime disputes off limits. Other cases, well, will China also boycott any case brought against it? I think if I have to bet on it, I would say yes, China probably would be on the side. But as I said, appear or not to appear, it's a complex issue. You would hope the Chinese government would carefully weigh the benefits and detriments, the pros and cons in every case, and make a decision on a rational basis.
Thank you very much. I think he has a second question about the China's participation in trade and investment and other issues. I think you mentioned in the beginning that your discussion would be confined to public international law disputes. So I think that I would assume it has been addressed, unless Mr. Raymond Gao doesn't agree. I also see another question from Zhou Fangyu. regarding whether the principle of competence. So has it been accepted in public international law?
Well, it's in the international. It's in almost in every international treaty establishing an international court or tribunal. The idea is that the court has the inherent power to decide on its own jurisdiction. That principle you can find in every international treaty setting up international courts. China does not really dispute that, although in China's response to the South China Sea arbitration awards, including China's academic critique of the awards, China tried to carve up some exception to that principle. But much of the arguments, I think, is quite weak. This principle, the court having the power to decide on its own jurisdiction, is actually widely accepted all over the world, not only in international law, but in domestic law as well. So I don't think you can, you can dispute that.
Thank you very much. Are there any other questions from the audience? Well, we are waiting for the questions. I have actually have a question, not a new question, but we will really appreciate your perspective on this. So the U.S. in the Nicaragua case. So the verification approach. So you take part in the jurisdiction and you challenge the jurisdiction, and then if the tribunal insists that it has jurisdiction, then you withdraw from the whole process. What about that approach vis-a-vis non-appearance?
Yeah, I think the approach taken by the US in the Nicaragua case, which was the partial non-appearance. In other words, the United States participated in the first stage, which is to decide whether the court has jurisdiction. The United States participated in that, they lost, and then they walked out. Well, should China or could China have taken a similar approach in the South China Sea case if they could participate in the first stage of the arbitral hearing? Well, there are important benefits for China to do that. If China should decide to participate in the first stage, the jurisdictional phase of the hearing, that means China can appoint an arbitrator. That means China can influence the formulation of the rules of procedure in the arbitration case. And that also means China will be able to present its arguments and respond to whatever allegations or arguments that the Philippines may have made. So in other words, there will be you would think that there will be a much better chance that China could win in the first stage. And of course, there's no guarantee that the result will be different, but you have a better chance if you participate. Now, the downside of that is that if you lose the first stage, like the United States did in the Nicaragua case, to walk out of the courtroom halfway in the process would look really bad. It would hit on your reputation really bad. And also it makes it difficult to deny the legitimacy or the credibility of the court afterwards, right? In China's case, because they did not participate at all, they did not even appoint an arbitrator, and that enables the Chinese government to say that this arbitral tribunal is just a bunch of clowns and they don't have any legitimacy, any authority, etc. Obviously, that argument would not work or could not be made if you have already participated. So, as I said, non-appearance carries this little benefit of denying the legitimacy of the court if you boycott the proceedings from the beginning. But obviously, whether or not the court has legitimacy ultimately needs to be decided by the international community. But in the domestic audience, perhaps that would be an advantage if you boycott the proceedings from the beginning. What do you think, Jerry?
Professor Gao, you have any questions or comments?
I have some comments on your colleague Professor Forzia,
Yeah.
because Dr. Forzia, she just mentioned about the white paper or position paper made by Chinese government in December 2014. The Chinese government expressly said that position paper was not a counter memorial. But I see a danger in that kind of participation in the name of non-participation, because in the whole oral hearing, actually the Philippines argued that the position paper of Beijing government did not address the issue of non-existence of dispute. That is a part of the admissibility issue. So Philippines argued that the Beijing government admits that there's no such kind of a question of lack or the non-existence of dispute. So I feel that if Chinese government would like to stay out of the arbitration, then at the same time presenting a position paper, then that position paper must be comprehensive. Well, so I think that's the risk to run, that you don't participate, but you share your position paper, which is not comprehensive.
So if I may push you a bit further, the being comprehensive, the position paper was actually quite long. I remember there were 94 points or something like that. Yeah. It was actually quite a long paper. It was actually very comprehensive. So then what's in your mind the definition of being comprehensive in terms of a government does not participate but publish a position paper?
If a position paper needs to be, for a position paper to be considered as comprehensive, then you must address the issue of admissibility and the issue of jurisdiction, and the issue of merits, because in the South China Sea arbitration, the tribunal asked Philippines to send only one memorial instead of two memorials. So the deadline for China to submit counter memorial would be for China to counter the Philippines memorial, including jurisdiction issue, admissibility issue, and the merits issue. So of course, Chinese government says that the tribunal does not have jurisdiction. So Chinese government's position paper only address jurisdiction issues. But apart from jurisdictional issues, there are admissibility issues that can be addressed. So that is something that is missing in the position paper.
Oh, that's true. That's true. I do agree. Yeah, I do agree. Yeah. What do you think, Professor Ling, in this regard?
Yeah. Well, it is actually quite common in non-appearance cases that the non-appearing state will issue documents outside the formal court process, and these documents will pronounce the non-appearing state's position on the case. And these documents are often looked at and analyzed by the court in its judgment, as the tribunal did in the South China Sea case. Now, obviously, I suppose non-appearing states typically do that because they want to show to the world, their domestic audience, the international community, they want to show that they are justified in taking a particular position, right? You want to show that. But on the other hand, when you essentially show your cards, when you publish those papers, it makes the other side's job a little easier, right? The other side will know what really is your legal challenges, and they will be able to address that. In the South China Sea case, the Philippines, when they saw China's position paper, the position paper essentially made 4 objections to the court's jurisdiction and the admissibility of the case. The Philippines were able to address those 4 points point by point, blow by blow, all right? And then China would not be there because China was not appearing. So there was no response. There was no counter-argument from China's side. So, so as far as the court process is concerned, if you are not there, if you do not appear, you are going to lose the case. It doesn't really help if you issue a position paper on your website. But I suppose as a political matter, China will be able to say to the domestic audience, and we have our legal arguments. So,
are you saying that if the state choose not to take part in the case, not to accept the jurisdiction, then you better keep silent for everything and say nothing?
They typically do not do that. They typically, in the so in the recent cases, the cases of Guyana and Venezuela, Venezuela actually makes its position quite well stated in various diplomatic documents. They write letters to the court, they issue statements. In the Kenya-Somali case, Kenya refused to appear in the oral proceedings. Well, in that case, Kenya actually produced thousands of pages of documents stating their positions. So, so you see, it's not typically the situation that the state will keep silent as if they don't have anything to say. They want to say something. They want to show that they are justified, that their case has strength. But if you are not in the courtroom, your outside statements will not be very effective as far as persuading the court is concerned.
Okay, I do have one last question actually to both Professor Ling and Professor Gao. The common understanding or common argument is that so China didn't take part in the South China Sea arbitration. For those who like to vote to view it from a positive lens, is that because China didn't have the experience and expertise in international litigation, so there are not so many talents there, lawyers there, and simply don't have the resources and don't have the manpower, and so that was understood by many as the main reason. But things have changed. So after we all know that. I guess Professor Gao is actually in a better position to address this question because you were there, right? In the you were part of the mainland international law community. So the Chinese government has invested so much, tremendous resources in training international lawyers, and there's big armies being being nurtured, is growing. So which basically means you have investment, you will have a team, you have an army, and you have confidence. So will that change the prospect of China's future dealing with international litigation, including possible participation? Although it's quite clear from the official position that China so far, this is quite clear, right? So China says we do not accept compulsory jurisdiction on issues relating to sovereignty and territorial integrity. But will things change, and how soon it can likely be?
Yeah, I'll just make one quick point on this, Jiang Yu. I actually it's covered in my presentation, but I forgot to elaborate on that. I mean, you cannot seriously say that the Philippines have more expertise or resources than China, right? I mean, in most of these cases, you hire counsel from Western countries. Obviously, you will have to rely on your own government and your own diplomats to give instructions to the foreign counsel. But it's always the British, the French, and sometimes the American law professors and lawyers who will argue the case before the international court. I think in China's case, this is something that the bureaucrats probably would hate to deal with. The problem here is not just to hire, to find the proper foreign lawyers, foreign counsel to represent you. I think in the case of South China Sea, or perhaps this recent controversy regarding COVID-19, how it started and what is China's responsibility, in those touchy, sensitive cases, when you give instructions to foreign counsel, how much of your internal materials, your so-called state secret, do you want to divulge to foreign counsel? I think this must be a huge challenge for the bureaucrats, for the government officials in charge of these disputes. So as far as these people, these bureaucrats are concerned, I think they would very much like non-appearance. Let's boycott, right? Let's just dispense with all this trouble, right? In WTO and in investment cases, as far as I know, the Chinese government always will have a Chinese law firm who will engage with a Western law firm, and you will have a fire war to control this flow of sensitive information from the government to the foreign counsel. I think there is lesson, or there is experience to be learned in China's WTO experience. But will that change the situation for public international law cases? I doubt that. Michael, you have any view on that?
I agree with Ling Bing's observation that if in the future Chinese government would like to participate in the second wave of South China Sea lawfare, then probably Chinese government will hire foreign lawyers. But here there's a question, because according to what I heard, that most of the good lawyers, most of the good public international lawyers are retained by Philippines, Vietnam, Japan, Malaysia. So it's kind of hard to discover the rising stars, the promising international public law lawyers to be a Chinese team. And for the international law scholars in mainland China, I would like to offer my different observation, because in China, the university professors, they are under they have the duties to fulfill, because they have an annual examination to review their performance. But in Chinese universities, they like to see their professors to publish papers in the CSSCI journals. Now, the CSSCI journals does not like to publish international law papers, international law articles. And now, since the page has been turned in terms of South China Sea arbitration, so only very few professors would like to continue digging into the legal issues of South China Sea arbitration and having the faith of his papers being publishable in the CSSCI. So So then there's only one way for those professors to publish their research, to follow up the South China Sea legal issues in the foreign international law papers, international law journals. But there are certain journals that consider this arbitration too much, because I once submit a paper to a journal, a very, very famous journal, and the chief editor told me that he asked me, he said that we cannot accept your paper, not because of the quality, but because of the topic. We are fed up with the South China Sea arbitration. So then it will be for those professors whose face are so thick that who would like to run the risk of having no papers published in Chinese language in CSSCI and struggling for publication in the foreign law journals, and to wrap up the arguments so as to not to look like a government agent or the pro-Chinese argument. So, well, this is my observation concerning the difficulty of continuing studying of this quite important and sensitive issue.
John, if you have time, can I just step in? Yeah. Yeah. My daughter is coming in she wants to see who is on that, and she wants to talk to everybody. So I agree with both Professor Gao and Ling Bing for the comments that they mentioned in relation to specifically about the position paper that the China has published in 2014. I would beg to disagree that it's not very comprehensive. I think, as Professor Ling Bing rightly mentioned, you don't want to really show all the cards that they have. They need to keep some things up their sleeves, up the sleeves, right? So, and the other issue that I would raise about I think the linguistic part is also very important, because sometimes I'm not Chinese. So I think that sometimes when you try to brief someone to do something for you, and that doesn't exactly turn out to be what it is in English. So I think that for China, when they published this position paper, the aim probably was to make clear the historical rights in that area. And I think it's quite consistent with what China has done previously before, for example, traditional Chinese approach to the boundary disputes. For example, during the Qing dynasty, government rejected the Portugal's request to defer the Macau-related boundary disputes to permanent court of arbitration. And the same goes with the Belgium that Professor Ling Bing mentioned. And I think that's very consistent with what their position is in India-China border disputes, where China has rejected completely that resolving the matter through sending it to ICJ. So I think that the major point I think that paper had to go through is that to sort of give some legitimacy to the historical rights, which internationally, when we look at the ICJ cases, that in deciding the territorial disputes, it comes at the end tail of the list of factors that could be considered by the court, in deciding the dispute. I think that's that I want to make a point. But I would also like to, because I'm not Chinese, so of course I don't speak the language. So and that goes back to what Professor Ling Bing mentioned about divulging these documents. And the question is, again, translating these documents first. Even if you hire an international lawyer, you will have to translate them to them first, and whether the translation will be exactly correct the way the China sees it. Again, the cultural differences, how China perceives things, and how Western lawyers will construct them. So that would be a problem. So that's why I think that's why China may be not hiring, or maybe they are, or not have faith in the international Western lawyers. And that's why they want to probably grow the homegrown lawyers who probably go to West and learn these jargons, if you like, the Western ideas, and then come back and translate them in their own way. I think that probably is my sort of a comment, my reflection on this. Thank you.
Thank you very much, Fauzia. I think that's very much all. I do see two questions in the chat box, but I think they have been excellently addressed in the comments of all the three speakers. Again, thanks to all of you, to the presenter and to these discussants for the wonderful presentation and also very dynamic discussions. It's a feast. It's a feast of great ideas. We have to call it a day, and the seminar has lasted much longer than it was originally planned. We were supposed to end at 4:30, but now it's almost 5:20, almost an hour. So, and still have a lot of audience and hanging around with us. So if this is a physical meeting, it will be my pleasure and obligation to invite all of you for a dinner. But I still consider that as my long-term obligation. So in case we can get together, let's do it. Thank you very much again, and for the audience, our center have more and more exciting events like this in the future. Please stay tuned. Thank you very much. So that's the end of the seminar. Thank you very much.
Thank you,
Professor Gao, Professor Ling, and Fauzia.
Thank you so much, and have a great evening, everybody. Bye-bye.
Bye.
Bye-bye.
Bye-bye.
Okay, wow. Thanks, bye.